Start. In the rejoinder affidavit filed by the petitioner against the contentions raised in the writ petition, he denied the averments made in the counter affidavit and stated that no demand notice was given to the petitioner nor the allotment cancellation order dated 23.8.2006 was ever given to the petitioner and no such documents have been annexed with the counter affidavit, and hence the cancellation order was not in the knowledge of the petitioner and is denied. Full stop. The cancellation order was never served upon the petitioner, only a communication regarding the said order was given by respondent number 2, on the basis of which he immediately applied for recall of the cancellation order on 24.8.2006. Full stop. Since respondents number 2 and 5 were not considering the recall of the cancellation order and were planning to take possession of the property of the petitioner, and thus he had to file the writ petition, it is apparent that they delayed the decision on recall application deliberately, and hence they cannot claim any extra charges from the petitioner except those provided in clause 11 of the brochure. Full stop. It is further submitted that there is no government order dated 20.11.1999 on record, and in the brochure there is no provision that once an allottee defaults in payment of installment, the casting guidelines of the government order dated 20.11.1999 shall be applied to his case, and the conditions given in para 11 of the brochure has become redundant. Therefore, the petitioner cannot be compelled to pay charges beyond the scope and ambit of clause 11 of the brochure. Full stop. It is further contended that why the prevailing rate on 9.10.2006 was taken into consideration when clause 11 of the brochure did not provide the same, which has not been explained by the respondents. Full stop. It is further provided that according to clause 11 of the brochure, if the highest bidder / auction purchaser wants restoration of the cancellation order within 1 month from its cancellation, then he is required to deposit the entire due amount with penal interest and 7% restoration charges of the value of the land, and thereafter an order of restoration of his allotment order shall be passed, and the remaining cost of the plot shall be payable as per the terms and conditions agreed earlier. Full stop. Para. From the contentions raised in the accompanying affidavit to the writ petition, in the counter affidavit and rejoinder affidavit, the main controversy which arises in the present writ petition is whether the parties who have entered into an agreement as per contentions of the petitioner void annexure 2, and it is not denied by the respondents whether the parties of the contract or agreement are bound by the terms of the agreement as they were on the date of the execution of agreement, that is 1.2.2005. Full stop. Annexure 2 of the writ petition is the agreement executed between the parties. Full stop. Admittedly, the agreement was executed in between Meerut Development Authority and the petitioner, a copy of which is annexed as Annexure 2 to the writ petition. Full stop. Para. It is nowhere stipulated in the agreement Annexure 2 to the writ petition on record that the market value or the circle rate, which shall from time to time be settled according to the future government orders, on such rate which shall be prevailing on the date of order, shall be recovered from the purchaser. Full stop. The question is that when an agreement has been arrived at between the parties, then both the parties are bound by the conditions as has been laid down in the agreement or in the information booklet provided in connection with the plot which was allotted, full stop. Hence, they cannot exceed or go beyond the conditions and stipulations as provided in the agreement itself, as well as in the brochure supplied with the offer, full stop. Since there is no such stipulation in the agreement itself, comma, so the order dated 29.12.2006 in bracket annexure 7 to the writ petition bracket out, order dated 20.1.2007 in bracket annexure 8 to the writ petition bracket out, and order dated 9.7.2007 in bracket annexure 12 to the writ petition bracket out shall have to be considered in the light of the agreement and the brochure showing the conditions and stipulation. The appellant filed his response in the proceedings on 28 December 2012, full stop. During the pendency of the proceedings, he is stated to have gifted the property comprised in the instrument to his wife Srimati Vijaya Jain on 17 December 2012, full stop, para. During the course of the proceedings before the second respondent, comma, an order came to be passed on 23 October 2013 calling upon the sub-registrar to conduct a fresh site inspection of the property and submit an actual status report, full stop. Pursuant to the aforesaid order, comma, the sub-registrar is stated to have submitted a report dated 16 November 2013 recording therein that the property in question appeared to have been put to use as farmland, full stop. The second respondent, upon a consideration of the material before him, has proceeded to hold that the land in question falls in the vicinity of the Greater Noida Industrial Development Area, where land is largely being used for residential and commercial purposes, full stop. He proceeded to hold that, bearing in mind the area of the property, comma, it was not possible to be utilized for agricultural purposes, and that the appellant himself owned no premises in the vicinity of the land in question, comma, which may lend credence to the contention that the property was to be utilized for agricultural purposes only, full stop. On a consideration of the aforesaid facts, the second respondent accepted the initial report submitted by the sub-registrar on 7 December 2012 and proceeded to pass the order which was impugned in the writ petition, full stop. The order passed by the second respondent against Srimati Vijaya Jain, comma, was subjected to challenge in a writ petition which too came to be dismissed by the learned single judge on the ground that she had an equally efficacious remedy of filing an appeal under section 56 of the Act, full stop, over.